Hello and welcome to today's webinar on the removal of executors or administrators. For those of you who don't know me, my name is Ali Toe. I'm a Senior Associate in the Dispute Resolution Group here at Boyce Turner, and I will be hosting today's webinar. This webinar is a live webinar, so please feel free to post any questions you may have as we go along through the chat panel. This webinar may raise a number of questions, so please bear with me. I will try and answer your questions at the end of the webinar, but for any of those that I'm unable to respond to, I will endeavour to get back to you separately. I may not be able to answer specific questions on air, as I may need to understand more about the context of the matter and the question. However, if you do need to talk to me about a specific matter, please contact me directly and I will come back to you separately. Although live, today's webinar is in listen-only mode. However, as I say, you can send us any questions or comments that you may have through the chat panel, and I will do my best to answer as many of them as I can at the end of the webinar. Today's webinar is the last in a series of webinars that we've been running throughout the year on the question of contentious probate claims. Previously, we've covered lack of testamentary capacity and wanton knowledge of approval of wills, undue influence and forgery of wills, rectification of wills, lost wills and deathbed gifts, proprietory estoppel claims, and Inheritance Act claims. But today, as I say, we're going to be looking at the question of removal of executors or administrators. Applications for the removal of executors if the deceased had made a will, or administrators if the deceased did not make a will and so died intestate, can be tricky applications. There are various reasons why an application for removal might be made. For example, there may be conflict between the interests of the executors or administrators and their own interests. This often occurs if the executor or administrator is also a beneficiary under the will. It may be that the persons with primary entitlement to the grant of probate or letters of administration, the official documents necessary in order to administer the estate, dependent on whether the deceased had a will or not, are unwilling or unable to get on with the administration of the estate. There may have been a complete breakdown of trust and confidence between the executors or administrators and the beneficiaries, which is impeding the due administration of the estate. Or there may be an issue which needs urgent attention before a full grant of probate or letters of administration can be obtained and the estate administered fully. It may not always be necessary for an application to be made to court to remove an executor or administrator. An executor can voluntarily waive their right to obtain a grant of probate, in which event the right to administer the estate will pass to the remaining or substituted executor, or if there is none, and or in the case of administrators, then the order of priority of persons entitled to administer the estate will apply in the usual way. This is known as renunciation. Renunciation is only possible if no grant has been obtained and the executor or administrator has not intermeddled with the estates in any way. If there's no remaining or substituted executor or administrator, then usually a professional appointment will take place. For example, a solicitor or an accountant. If renunciation is not possible, then consideration will need to be given as to whether a formal application to court will need to be made. There are two potential available avenues. Firstly, Section 116 of the Senior Courts Act 1981. Applications are made to the Registrar of the Probate Registry or the Principal Registry and must be supported by affidavit evidence. The application is usually made without notice, and the registrar will then usually give directions as to service, etc. Secondly, Section 50 of the Administration of Justice Act 1985. Claims are usually Part 8 claims made in the Chancery Division of the High Court and must be supported by witness evidence. In Section 50 applications, the court has the power to remove the executor or administrator and substitute them even if they have intermeddled with the estate before their removal or have already obtained a grant of probate or letters of administration. It also has the ability to do so in circumstances where a person would have been entitled to a grant but has not yet applied for one. However, the remedies are not so wide with Section 116 applications. With these applications, the registrar only has the power to pass over the rights of someone who would otherwise be entitled to a grant of probate or letters of administration in favour of someone else. He would not, however, be able to remove an executor or administrator who had already obtained a grant of probate or letters of administration. In Section 116 applications, the court may only remove an executor or administrator if it appears to the court to be necessary by reason of any special circumstances. There's no requirement for there to be any special circumstances with Section 50 applications. There is no guidance in relation to what might be considered special circumstances within the Senior Courts Act, but examples that the court has accepted as special circumstances include applications where executors or administrators cannot be found or are unwilling or unable to take out a grant of probate or letters of administration, and in one case where the potential executor was under the investigation for the murder of the deceased. A court order is necessary to give effect to an application to remove an executor or administrator if renunciation is not possible. The order will be sealed once a grant of probate or letters of administration has been issued. However, it's not necessary to wait until a grant or letters of administration have been obtained in order to bring the proceedings. Whichever route is chosen for the application to be made, it's also important to have regard to the question of trustees. Often, a testator's will appoint an executor and trustee of their estate. If there are ongoing trusts, consideration will need to be given as to whether or not any order for the removal of an executor will also have the effect of removing that person as a trustee as well. The position may turn on the wording of the will itself, or indeed the court order, but where the will makes a distinct appointment of executors and trustees, then applicants will need to consider whether they wish to remove both or just the executors. There is no formal guidance in either Act to assist the courts when deciding whether or not to invoke its power to remove an executor or an administrator. However, assistance can be gained from common law, and in particular the case of Harris v. Earwicker, where Chief Master Marsh set out some general principles for the court to consider. These included, importantly, it's not necessary for the court to find any wrongdoing or fault on the part of the executor or administrator whose removal is being sought. The guiding principle is whether the administration of the estate is being carried out properly. If this is not the case, then the court will usually order the removal of the executor or the administrator. This would also be the case if the executor or administrator whose removal was being sought had in fact been guilty of wrongdoing or fault, which was sufficiently material enough to endanger the estate. The question for the court to consider in cases where there is wrongdoing or fault will be whether such acts have affected the administration of the estate or its assets. The wishes of the testator, as reflected in the will if one was executed, concerning the identity of their preferred executor is a factor to take into account. The wishes of the beneficiaries may also be relevant. However, the beneficiaries have no automatic right to demand replacement. The court has to make a balanced judgment, taking a broad view about what is in the interests of the beneficiaries as a whole. Another consideration is whether, in the absence of any significant wrongdoing or fault, it's become impossible or difficult for the executors or administrators to complete the administration of the estate. The court will need to review what has been done to administer the estate and what remains to be done. A breakdown of the relationship between some or all of the beneficiaries and the executors or administrators will not, without more, justify their replacement. However, if the breakdown of the relationship makes the tasks of the executors or administrators difficult or impossible, replacement may be the only option. And the additional costs of replacing some or all of the executors or administrators, particularly where it is proposed to appoint professional persons, is a material consideration. The size of the estate and the scope and cost of the work which will be needed will have to be considered. Cases involving applications to remove executors or administrators are rarely reported. It's probably not because the cases themselves are rare, but more because the outcome of the applications are not particularly surprising and do not give rise to any new law. I've done a few of these applications myself now, and as I said at the beginning of this webinar, whilst they can be tricky, the results are not usually that startling. Nevertheless, there are some reported cases, so let's look at a couple now. So firstly, in Loftus, a case decided in 2005, the deceased, Ivor Loftus, died intestate on the 11th of August 1990. He was survived by his 5 adult children. The first defendant, Margaret, who was one of his children, was granted letters of administration in 1991. The appointment was made without the knowledge of her siblings. In early November 1991, the matrimonial home was placed on the market for sale at £95,000. Mr. Loftus' estate also comprised his 90% shareholding in his building company, some personal chattels, and some land lying to the south of Headstone Drive, known as the Yard, from where the business operated. Margaret proceeded to frustrate the sale of the matrimonial home and later sold it in her own name, leaving her, after payment of inheritance tax and fees, a sum of about £50,000. Various meetings took place between the siblings with a view to trying to agree a distribution of their father's estate, but without success. In 1992, Margaret then executed an assent, transferring title in the yard to herself. This resulted in separate litigation as regards the business's entitlement to use the land, which was eventually settled in about 1995 or 1996. However, shortly thereafter, the business ceased to trade and was subsequently dissolved. In 1999, Margaret then transferred title in the yard to her son, Dexter. In consideration for the transfer, Dexter agreed to pay off the mortgage on the yard, which amounted to about £26,000, and he also paid Margaret a further sum of about £14,000 in cash. In August 2003, Margaret's estranged husband, Chris, wrote to one of her sisters, Sheila, enclosing extracts from an affidavit which she had sworn in connection with their divorce proceedings, wherein she had said she transferred the yard to Dexter. This was the first time that Sheila and her other 2 sisters, Angela and Catherine, had known about the transfer. As a result, the sisters issued a claim in the family division seeking an order that Margaret give an account and inventory of her dealings with the administration of the estate, which resulted the following year in them obtaining further details regarding the transfer of the yard. There were also various other disputes between the siblings, including monies in an offshore account and property allegedly held by their father in Ireland. All these matters still remained unresolved in 2003, and so on the 20th of January 2003, the sisters commenced further proceedings against Margaret and Dexter, seeking inter alia an order removing Margaret as executor and appointing a professional person in her place, as well as an account of the administration of the estate and payment of such amount as was found to be due. The sisters alleged that Margaret failed to provide any adequate accounts, failed to complete the administration of the estate, and failed to make any distribution of the estate, and further that her mortgage of the yard and subsequent transfer to Dexter were in breach of trust. The sisters also sought an order that Dexter held the yard on trust for the estate and that he should transfer the same back to the estate. Having regard to Margaret's actions, the court had no hesitation in granting an order that she be removed as the executor of her late father's estate and appointing an independent solicitor in her place. As an aside, the court also made an order that Dexter did hold the yard on trust for the estate and that he should therefore convey it back to the estate, together with ancillary orders relating to all rents and profits in relation to the yard during the time when he was in possession of the same. And then in the Harris and Earwicker case, which is the one I mentioned earlier before Chief Master Marsh, which set out some guidance for the courts in connection with applications of this nature, Mr. Lafleur made an application to remove the executors of his late father's will. Mr. Earwicker had died on the 23rd of March 2012. Probate was granted to his executors on the 15th of October 2012. The issues in the claim arose from the provisions of Mr. Earwicker's will, dated the 14th of April 2011, which had been prepared by Mr. Harris, a solicitor on one of the executors, the other two being an accountant, Mr. Clegg, and Mr. Mason, a personal friend of Mr. Earwicker. The executors did issue proceedings seeking declarations in respect of the issues with the will, but in the meantime, the relationship between them and Mr. Lafleur, who was one of the residuary beneficiaries under his late father's will, had begun to break down. One particular issue centred around Mrs. Earwicker's right to an annuity and how this was to be funded. The executors issued proceedings in this regard, seeking declarations from the court, which were granted, leaving them free to move forward with the administration of the estate. But Mr. Lafleur still issued an application for their removal, contending that they had failed and continued to fail in their duties as regards the administration of the estate, including, for example, not obtaining a proper and fair sale price for Mr. Earwicker's property and failing to adequately secure the property prior to sale from unlawful entry. Chief Master Marsh concluded that it was not uncommon that administration of an estate led to ill feeling and distrust. Sadly, in this case, the children's feelings regarding their father, at whose hand it was alleged they had suffered, was compounded by a dislike of Mrs. Earwicker, who was Mr. Earwicker's third wife, and her son, together with a general disappointment regarding the provision of the will itself. The Master stated that it was plain there was a complete breakdown of relations between Mr. Lafleur, his siblings, and Mr. Harris, with relations with Mr. Clegg and Mr. Mason being somewhat strained. However, this did not necessarily mean that the executors should be removed. consideration had to be given to the effect of this on the administration of the estate. The starting point was to consider what was left for the executors to do. The estate was largely wound up. The remaining work arose mainly under a trust which had been set up by the will. It was possible that the property occupied by Mrs. Earwicker may need to be sold and alternative property purchased for her as she got older. Indeed, as the will provided for Mrs. Earwicker to request that alternative accommodation be purchased for her at any time, this could occur more than once. Careful decisions would need to be made in this regard, and the residuary beneficiaries had an interest in the way in which the trust was run. The residuary beneficiaries comprised Mr. Earwicker's 4 children and a charity. The charity did not wish the executors to be removed, whereas the children did. Mrs. Earwicker also wished the executors to remain in place. Chief Master Marsh said he had the distinct impression that Mr. Earwicker had thought carefully about the persons he wished to appoint as executors. And although his wishes were only one factor, they did carry real weight, particularly where the beneficiaries were divided about the need for a change. Having applied the relevant guidance points, Chief Master Marsh concluded that there was no advantage or benefit in removing Mr. Clegg or Mr. Mason. As to Mr. Harris, against whom most of Mr. Lefeur's complaints were made, Chief Master Marsh considered that there was no reason to find wrongdoing or fault on his part. However, he had taken a realistic position in recognising that it may not be helpful for him to continue, given the barrage of criticism he had faced. Chief Master Marsh therefore considered that it was in the beneficiary's best interest as a whole and for the smooth running of the will trust if he was removed. However, he refused to remove Mr. Clegg or Mr. Mason. So that concludes this webinar on the removal of executors and administrators. Does anyone have any questions? So as there are no questions, this concludes this webinar and indeed the series of webinars that we've been running over the last 6 months. I hope you have found them of some use. If there is any topic that I didn't cover or any other questions that you may have in the future, please do get in contact with me. You can see my details on the screen. In the meantime, it just remains for me to say many thanks for listening. Thank you and good morning.